Hi, everybody, and welcome to today's webinar. Thank you for being here. My name is Tran Mendez, and I'm an academic trainer with the Center for Teaching and Learning. And today's topic is Improving Your Legal Research and Writing Skills, presented by the School of Business faculty, Dr. Shellie Rebman. And she is going to be going over lots of great tips, and I'm sure everybody is going to be as excited about today's content as I am. And before we get started, I just have a couple of housekeeping items to take care of. I wanted to remind everybody that this webinar is being recorded, and I will post it in the comments in the CTL webinar page later on today. If you don't have access to the comments, please send us an email to ctl@ncu.edu and we'll help guide you to where you can locate the webinars. If you have any questions throughout the webinar, just use the Q&A or the chat tools located at the bottom of your screen. If you are using the Zoom app on your phone or iPad or tablet, you have to scroll through your options to locate these tools. But we want to hear from you throughout the presentation. So please use those tools to let us know if you have any questions or comments. And with that, I'm going to go ahead and turn it over to Dr. Rebman.
Hi there, and welcome. As Tran just said, my name is Shellie Rebman, and I'm lead faculty for the Master in Legal Studies program. Today we are going to be discussing legal research, legal analysis, and legal writing. All three of these skills are fundamental to the practice of law. It is how the various parties in a legal action communicate their ideas and positions on the legal issues. So let's jump right in and get started. Legal research. Legal research is the process of gathering information to support and strengthen legal analysis. Your research begins with extracting the relevant facts and legal issues. Then you use that information to develop strategic search terms that will lead you to applicable case law with the same or similar facts and law. You will then apply that research in your analysis to determine how the law should be applied to the facts of your case. Legal writing is a technical form of writing used in the legal community to communicate legal research and analysis. Every sentence and every position must be backed by assertions and citations to authority. Therefore, a Blue Book citation should appear at the end of, if not all, then most of the sentences in your legal document. This is how you establish that your analysis is well-founded and supported in the law. Legal analysis. Legal analysis is the process of applying law to the facts of your case to arrive at a logical conclusion. It is very methodical and goes step by step. A simple example is, if you have fact A and you apply law B, the only reasonable conclusion is C. So let's say that your client ran into the back of the vehicle in front of them. And the law states, unless proven otherwise, there is a legal presumption that a vehicle that hits the back end of another vehicle is liable for any injury to person or property. Logic demands that you come to the conclusion that your client must pay for any property damage or personal injury resulting from the vehicular accident. In this webinar, I will be using a hypothetical legal case to demonstrate how you research, analyze, and write a memorandum. This is different from writing a case brief or IRAC, but you will find all of the same elements are present and essential in a legal memorandum too. So your firm has assigned you to assist with a new case. While reviewing the file, you find the following information. Sally Summer has a 5-year-old shelter dog named Bouncer. Sally has never had DNA testing done on Bouncer, but there are some definite traits for the breeds Pointer, Pit Bull, and Beagle. Sally often sits on her front porch with Bouncer and watches other dogs walk by. Bouncer will bark, growl, and sometimes raise his hackles when other dogs walk by, but as long as Sally is sitting there, then he will not go after the other dogs. However, Bouncer is quite an escape artist. He is very fast and sometimes he dashes out the door without Sally seeing. When Bouncer does this, he will travel around the neighborhood trying to play and generally causing a ruckus with some of the neighborhood dogs. He also likes to chase the children as they run around the neighborhood. Neighbors have complained to Sally about Bouncer's behavior, but not once has someone told her that Bouncer hurt a person or another dog. Last Tuesday, Wendy Wynn was taking a walk with her 3-year-old daughter, Susie. Wendy ran into a neighbor, and as they were catching up, Susie saw Bouncer laying in the front yard. Every day, Bouncer gets a dog bone. This is his treat for the day. He was enjoying his treat when Susie came running toward him. Susie kneeled down in front of him, as she had learned to do, but she accidentally put her hand over part of the bone. Bouncer barked at her, and when she still didn't move her hand, he bit one of her fingers. Susie went running to her mom, showing Wendy the bite. As Wendy was looking at Susie's bite, her neighbor, Nosy Nellie, came over and told Wendy that Bouncer was always chasing children and picking fights with the other dogs in the neighborhood. Wendy took Sally to the emergency room, where the doctors found that Bouncer had nipped off the top of her finger. The doctors told Wendy that Susie's finger would be deformed as a result of the dog bite. You have been asked to research this case and draft a legal memorandum evaluating Susie's case. Here are the step-by-step instructions on how to conduct the research, analyze the issues, and write the legal memorandum. First, you need to identify any possible legal issues. The legal issues, they generally revolve around liability. In this case, the liability revolves around whether Sally is responsible for Bouncer biting Susie and causing her injury. So once you identify the legal issue, you want to pick your strategic search terms. Remember that you are looking for case law with similar laws and facts to your case, so your preliminary search terms will come from the facts of your case. Possible terms in this case might be dog bite, dog owner liability, and provocation. You can also use your research in your research. Most cases include multiple cases and/or statutes that they have relied upon in arriving at the decision. You can review these laws and cases to determine if they are applicable in your case. In addition, you might find other keywords that you can add to your search terms in the other decisions. Westlaw is a legal resource found in the NCU library. There are 2 ways that you can access Westlaw. First, there is a link to Westlaw that can be found in the Legal Resource Guide in course materials. You can also access Westlaw by clicking on the A to Z database, which can be found in the brown bar at the top of the library homepage. And then you click on W, and Westlaw will be the second source. Click on that, and then just jump right into your research. You always start your legal research looking for primary and binding legal resources. Primary resources are those that dictate the law, such as statutes, constitutions, and case law. In the United States, the legal decisions of appellate level courts are binding on the lower level courts in the same jurisdiction. The lower courts are required, meaning they have no choice but to adhere to the law established in those higher courts. This is called precedent. If you can't find any applicable research from your state, you can broaden your search to other jurisdictions. And generally, you start by looking at nearby jurisdictions and then broaden the scope as you have to. You start with nearby jurisdictions. You look to the ones that are like in the same circuit, federal circuit level as you, because being from the same kind of general area, you tend to have the same values, morals, those kinds of things. Then say Missouri would with California. Missouri would look to Iowa or Nebraska. as just a couple examples. Cases from other jurisdictions, they are primary sources, but they are not binding, meaning that they can only provide guidance to the courts in your jurisdiction. They don't have to follow them. If you still aren't having any luck finding applicable case law or statutes, etc., you can look to secondary sources. Secondary sources are treatises, law journals, ALJs. There's lots of different types of secondary sources. Secondary sources, they provide guidance on the proper interpretation and application of law, but they're never binding. They're never binding on any court in any jurisdiction. So those are the lowest level. If you would do a hierarchy, those are at the lowest level of the legal resources that you want to find. Blue Book citations. I am so very excited to announce that you will soon be receiving access to a digital copy of the Blue Book. I sincerely apologize for the fact that we have not been able to offer you this resource before now. However, in the meantime, there are 2 links in the Legal Resource Guide that can be found in the course resources. Disregard the first link, and the second link takes you to Cornell University Law School. This provides you with instructions and examples on how to formulate your legal citations. If you look at the menu on the left side of the screen under How to Cite, you will find the different types of legal resources. Click on any one for instructions and examples on how to cite that resource. The next link is to the Valparaiso University Law, and it provides you with the tables for the abbreviations to state and federal resources, as well as secondary sources. These are the abbreviations that you will be using in the Blue Book citations. But we're going to have the Blue Book available for you, so hopefully no need to even use those anymore. You can also I did want to let you know that you can find the Blue Book citation for all resources found on Westlaw. It's really simple. You just highlight the portion of the content that you want from the statute or case law, and then you kind of highlight it, then you kind of hover there, and it'll come up with copy with reference. You hit that copy with reference and then drop it into your outline or your paper, whatever you're working on. It'll provide the content that you wanted, and then it'll be followed by the Blue Book citation. If you don't want to copy any text, that's just fine. Just highlight like any word, like to or from, and then click on the copy with reference, and it'll provide you the Blue Book citation when you paste it onto another page. I recommend that you determine the proper Blue Book citations for each resource as you find it. It just makes it a lot easier in the end when you're constructing your analysis. You don't want to be going back then trying to figure it out. It's best just to have everything in order by the time you're at this point of your analysis. Site checking. Site checking is it's actually very simple, but it seems to cause a lot of issues. When you site check a case, you're just reviewing any and all cases that have included that case in their analysis and discussion since that case was decided. You do this to make sure that the law that you are relying upon is still good law. So if there's a yellow flag next to the case name, that means that the case has had some negative treatment since it was decided. Now, negative treatment can be about anything. It can be about any single factual issue, legal issue. So you really need to review the case to see what the negative treatment was and to determine if that is applicable to the facts and legal issues in your case, because it may not be. So in those times when you determine that it is not applicable to your case, you can, it's like a term of art, distinguish it by pointing out excuse me, the fact that the negative issue revolved around a different fact or legal issue. If the case cannot be distinguished, you would still include it in an objective legal writing as a counterargument, but not in a persuasive legal document. If there's a red flag, it means that the case was overturned. Again, it can be overturned for many reasons, so you must review the case to see if it can be distinguished from your case. Excuse me. As a practical matter, you should try to avoid cases with red flags, even if you can distinguish them. I've found that they can only confuse the court, and really you don't want to create any confusion. You want it to be black and white. If you cannot find another legal authority, you can use that case. You just have to explain to the court why it should decide differently from that case, from the case that it was overturned in, and applied differently to your case. If there's no flag, that of course means that the case is still good law as is. So after I conducted Westlaw searches on dog bites, dog owner liability, and provocation, I found 2 Missouri cases with similar facts and legal issues. Now keep in mind, I'm doing this for, I'm trying to keep this brief and simple for the purposes of this presentation. Obviously, you would find statutes about it. You would find more cases than that. But I'm just going to keep it to these 2 cases for the purposes of this hypothetical. So both these cases are appellate decisions. So they are both primary law and binding on Missouri courts. So sorry, everyone. Here, my research resulted in Crimmins versus Murley. It's a Missouri case with similar facts. The dog caused some ruckus with other dogs and chased and nipped at children riding their bikes. But he had never hurt anyone, just like Bouncer. The court found that was not sufficient to prove that the dog was vicious or dangerous. Sayers versus Holter, I'm not really sure how to pronounce that, stated that provocation is a defense to owner liability for a dog bite. So once you have identified the law and the facts, you're ready to start on your legal memorandum. An office legal memorandum is a predictive statement of the law. That means that you are predicting, based upon your research and facts, how a court would apply the law to the facts in your case. Therefore, you need to maintain an objective tone and remember to address any counter arguments. Persuasive writing is very different. However, all of the same instruction and information about legal research, analysis, and writing applies to persuasive as well as predictive writing. And you'll use persuasive writing when advocating for a position of your client. So that will be like in motions to dismiss, motions for summary judgment, those kinds of documents. One of the main differences between the two is using a persuasive tone rather than an objective one. Some examples are, if you're writing a persuasive document, you might state, the court must rely upon the direction and decisions in Crimmins. Where if you're writing an objective document, you might state it as the Crimmins court provides guidance on how this court should blah, 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 blah. It's just a slight difference. And honestly, there is a difference, but if you don't maintain that difference, sometimes that's okay. All of this is just guidelines. They're directions on how to do this. But we all make lots of mistakes in the legal field, so this is by no means written in the Holy Grail. So the easiest way to begin a research and writing project is to develop an outline. Outlining your thoughts before you start writing helps you draft a clear, well-organized document that easily and understandably flows from one issue to another. The more complex an assignment, the more detailed your outline should be. A good starting point for your outline in this hypothetical case is to identify and list the legal elements and any defenses to the legal cause of action. So here, in Crimmins, you found that it's required that Bouncer had vicious or dangerous propensities, and 2, that Summer was aware of Bouncer's dangerous activities. And then from Sayers versus Holzhauer, you learned of the defense, provocation, which is a total defense to liability. Be sure, as you can see I've done here, if you include your Blue Book citations in your outline, it'll just make it that much easier when you convert your outline into your written paper. So now it's time to identify and include the relevant facts necessary to prove or disprove each legal element so you can see where you stand. So, for example, for the element that Bouncer had vicious or dangerous propensities, the evidence is that he starts a ruckus with other dogs in the neighborhood. He chases kids in the neighborhood. But Bouncer's never injured another dog or person. For the second element, that Sally Summer was aware of Bouncer's vicious propensities. There were neighbors who complained to Sally about Bouncer starting fights with other dogs and chasing the children. And then there was his behavior as he was up on the front porch with her, growling and barking at other dogs. Then you have the defense of provocation. And here, Susie unintentionally put her hand over Bouncer's dog treat. So that clearly can be considered provocation. So now that you have all your facts in line, you want to move to your analysis. So here we're just going to analyze the first element, just to keep it simple. So again, so your analysis again is where you explain to the court or to your client how the law should be applied to the facts of your case to resolve the legal issue. So using the same outline that you've been adding to, just add in your analysis under each element. So again, we're just looking at the first element, and that requires that Bouncer has vicious or dangerous propensities. So your legal analysis of this issue and the facts might include something like, well, Bouncer has caused ruckuses with other dogs, and he does chase the children around. Under Crimmins versus Murley, that is insufficient evidence to establish that Bouncer was dangerous. Therefore, there is insufficient evidence to prove that Bouncer had a vicious or dangerous propensity. And see how this follows the ABC pattern that I was talking about at the beginning of this presentation. So again, you have your element, which are the law, which is your A here, and then you have your facts, which are the B's. And so when you combine the law and the facts, this is the conclusion. The analysis includes the conclusion that you would have to come to. Oh, I did do the second element. I apologize. So the second element requires that Sally Summer was aware of Bouncer's vicious propensities. Your analysis might be something like, while neighbors complained to Sally about Bouncer's activities with other dogs and children, no one had ever told her that Bouncer hurt another dog or person. Therefore, there's no evidence to prove that Sally had notice of Bouncer's propensity to dangerous or vicious acts. And then finally, you have the analysis of your defense, provocation. So an analysis of this might be something like under Sayers versus Halter, provocation is a defense to a dog owner's liability. It is common knowledge that dogs are protective of their food, and Susie's unintentional act of putting her hand on the bone could have easily provoked a Bouncer. So now that you've completed your outline, you're going to start constructing your assignment. So you'll start with the headings, and then you'll include the paragraphs. So when starting a legal memorandum, or any memorandum, it's always going to come down to these fundamental elements. You have to have the legal issue, you have to have the facts, and you have to have the rule or the law on how those facts should be decided. So here in this memorandum, we're going to start with legal issue. And the legal issue in this hypothetical is obviously very simple. It's whether Sally Summer was liable for her dog Bouncer when he bit Susie Wynn's finger. Next, I would suggest you include the brief answer. And here, the brief answer, you just want to make it a concise statement of how the law should be applied or will be applied in this under the facts of this case. So under Missouri law, Sally Summer is not liable for Bouncer's dog bite because there is no evidence that Bouncer had a propensity to be vicious. However, even if he was dangerous, Susie provoked Bouncer by putting her hand on his dog treat, and provocation is a defense to liability. So you can see these are just two short, concise statements of what our analysis in our outline showed us. Next, you want to include the statement of the facts. So you want to make sure that you include only those facts that are relevant to the legal issue. So for example, here, I did include that Bouncer was part pit bull, beagle, pointer, or whatever. And I didn't include that Nosy Nellie was involved because her conversation with Wendy is not significant under our evaluation or our analysis. But you do, as a general rule, you want to make sure that the judge or another attorney does have sufficient information to be able to identify the key issues after reading the statement of facts. And you should work to write the narrative, or write the facts in narrative form, as if telling a story. Address the facts in chronological order to keep an easy and logical flow to your statement of facts. Legal writing is very dry, as you can see, so be sure to make the facts as interesting as possible. This just helps engage your audience from the beginning. You do not ever include argument in your statement of facts. It's just the objective facts that have been proven. You also want to avoid adjectives or adverbs or other embellishments. They're just frowned upon in the legal community. So in this case, my statement of facts would include, in this case, dog Bouncer bit Susie Wynn's finger, causing permanent deformity. Neighbors had complained to Sally about Bouncer causing a ruckus with other dogs and chasing children, but no one told her that Bouncer had injured another dog or a person. Sally unintentionally put her hand on Bouncer's treat. Bouncer barked at her, and when she didn't remove it, he bit her finger. It is common knowledge that dogs are protective of their food. And again, these are just the facts that are necessary to your analysis and conclusion. Analysis. So this is when you move your brief analysis from your outline and you expand upon it. And again, as I've told you, I think 2 times now, analysis is the process of applying law to the set of facts, to your set of facts to reach a reasonable conclusion. So here I'm analyzing the first element. I start by introducing the case that I will be relying upon in the analysis. So my sentence is, Crimmins versus Murley, the court reviewed facts very similar to this case and applied the same Missouri law to determine that the dog owner was not liable for the dog bite. From there, you will go into your analysis of the second element of knowledge and then the defense of provocation. Then I include a brief statement of the facts in that case that are similar to ours. So there, in Crimmins, the dog fought with other dogs over food and chased and nipped at the children as they rode their bikes around the neighborhood. From that point, I want to explain how the court resolved that legal issue in Crimmins. So I have here in Crimmins, the court found that the evidence was insufficient to prove that the dog has a propensity to violence. The court relied upon the fact that the dog had never hurt another person or dog in reaching its decision. So that was part of its analysis, that the dog had never hurt anyone. So now you switch to the facts of your case and identify the same or similar facts in your case. So similarly, in this case, Bouncer sometimes caused a ruckus with other dogs and chased the running children, but there was no evidence that Bouncer had ever hurt a person or another dog. And then finally, you apply the case to your set of facts to direct the court or explain to the court how it should decide liability in this case. So my statement is, under Crimmins, there is no evidence that Bouncer had vicious or dangerous propensities, and therefore plaintiff cannot establish the first element of liability. So as you can see, it's just it's letting the reader know a little bit about the case that you're relying upon, then showing why it is applicable in your case because it has the same or similar facts and law, and then using that decision to guide or direct the court that you're in on how to decide the case. The conclusion is where you summarize and tie together your analysis and make your conclusions. Here I included a conclusion of, here there is insufficient evidence to establish that Bouncer has a propensity toward dangerous or vicious behavior. Since plaintiff failed to prove the first element, the court must find that there is no evidence to prove the second element of knowledge. There is evidence, however, that Susie provoked Bouncer when she put her hand on his treat. Therefore, based upon the law and facts in this case, Sally Summer has no liability for the bite to Susie's fingers. So this ends the presentation part of this webinar. I hope you found that this is helpful, and this will be posted in the comments so that you can go back if you need to look at my notes and the presentation itself. Before we start the Q&A, I would like to make a couple comments about the MLS program and course content. We are aware that there are typos and other mistakes in the course content, and we are working diligently to clean those up. I would ask if agreeable that you help us do that by sending an email to your professor at any time that you find a mistake. In addition, this is NCU's first legal program. So understandably, the NCU library is limited in its legal resources. We did add Westlaw Campus specifically for this program, which is the primary legal research engine in the United States. But with other resources, we did have to look to external web-based resources. And the issues with those external resources are that they can be removed, their URL can change, any is a variety of reasons. Once again, if agreeable, you could really help us by sending us an email highlighting the resource that you were unable to access. And finally, I have heard some comments that the weekly resources are not relevant. If you find this to be the case, please send an email to your professor. We need your feedback to make this the best program that we can. And you're the ones who are in the moment. So please, any comments that you want to pass along about course content, we are happy to receive. And that concludes my part of this webinar.
Thank you for that, Dr. Rebman. So we had a couple of comments. It was very informative. I also found this webinar very informative and well done and to the point. So thank you for those comments. And then Mark Olson shared a couple of resources. And if it's okay with you, Dr. Rebman, if I can pull it up on my screen and
Sure.
just kind of show you what he shared, and you can give your comments on them.
Most definitely.
So I will go ahead and take the screen share. Okay, so the first resource that Mark shared was Court Listener.
Okay. This is a Westlaw Campus does what this Court Listener does. And again, it's the most widely used search engine in the United States. And so I really want to make sure that you all are proficient with using it before you leave this program. So I would ask that whenever possible that you do use Westlaw Campus to conduct your research. And then that way also you have the proper Blue Book citations for your legal resources too.
Great. And then the other two that Mark shared, the first one is fastcase.com, and then the other one is free.law.
Okay, I'm not familiar with either one of those either. And the first one looks like just another search engine. And can you click to the second one?
Sure.
Let's see. Let me see if I can. Can you move it up just a little bit?
Yes.
There we go. So it's an online archive. And, okay, so this is to assist with, there is public access, free public access to all the U.S. federal district and bankruptcy courts, as well as the circuit courts and the U.S. Supreme Court. But again, those federal courts are all included in the Westlaw Campus. And again, I really encourage you all to use Westlaw Campus. Once you start using it, it becomes very intuitive, and I really do. As I said, I really want you to become proficient with using that program. Okay.
Thank you for that. I'm seeing a couple of questions come through here. The first one is, hello, Dr. Rebman. In your hypothetical, you used one case, an example, of course. I was wondering if multiple cases can be used in a legal analysis.
Yes, most definitely. And I expect that there are multiple cases that are used in your analysis. In this case, I told you, I just chose those two cases because they were simple and to the point. But yes, yeah, the more, and again, it's, it's like I stated earlier, I mean, everything should have a citation after it. And in legal writing, you need to prove each sentence that you make. You need to prove it either by a court case, by the evidence of the trial court. I think I lost the train of thought. Will you read the question to me once again, Tran?
Yes. Dr. Redmond, in your hypothetical, you used one case, an example, of course, but I was wondering if multiple cases can be used in a legal analysis.
Yes. So I think I answered the question. Yes, most definitely, and it is expected.
Great. And then there are a couple of hands raised.
Can I add to that for just 1 second?
Yeah, go right ahead.
So even if you have a case that supports the sentence that you just wrote, if there are two cases that, if there's another case, then add that second case. If there's a third case, add that third case. The more support that you show in your analysis, the more credibility it's going to have with the court.
Thank you for that. And then Patrick, you've had your hand raised for a little while now. Did you have a question for Dr. Redmond? I'm going to give Patrick some time to respond. And then here is a question that came through the Q&A. I am a member of the New Mexico State Bar Paralegal Division. Will we receive a certificate of attendance in order to receive credit?
For, I'm assuming like you're looking for like professional development credit, maybe. And I don't know about paralegal, but I know with legal, in the legal field, we have to do continuing legal education, obviously, every year. And the seminars or conferences that we attend, they have to be pre-approved to count as, they have to be pre-approved by the state that I'm in for credit. So, with your question, I'm not quite sure. Obviously, this program has not been approved by anyone. So, again, I don't know if I'm answering your question, but I really want to. So, how about if we can follow this up with if you send me an email to srebman@ncu.edu, I'll be happy to discuss it with you further.
I'm going to share that in the chat real quick. And then, so Mark wanted to clarify with those tools. I use a lot of research tools for predictive analysis. Currently, I am working on my DBA at NCU. And this is the student that referred those three resources earlier. But it sounds like that you're recommending everybody use Westlaw.
In the MLS program, Mark is in a different program from what you just read. So yeah, in the Westlaw, in the Master of Legal Studies program, yes, I definitely want people to use Westlaw. And for Mark, if you haven't tried it, please give it a try. It's very easy to use, very user friendly.
Thank you. Do we have any other questions for Dr. Redmond? I'm just reading through the chat here to make sure I didn't forget anything. Oh, Mark shared he has an MBA in mediation and arbitration.
Okay.
Let me just check the Q&A. So the person that asked about the paralegal division in New Mexico, they clarified with CLE. Does
Yeah.
that
Yeah,
help
so,
with?
yeah, that means continuing legal education, which I'm not sure how it works for paralegals, but I know for attorneys, you have to, the program that you attend has to be pre-approved by your state for it to count as a CLE credit. So I'm not sure how New Mexico does that, but again, this master's program does not have any kind of a certificate that it comes with. It is just the degree itself, a master's degree, that you leave with.
So students that want to use this for continuing education should definitely reach out to their state.
Yes. Yes. Thank you, Tran.
You're welcome. Let me see. I think I see another hand raised. Carol, I see your hand is raised. Did you have a question? I'm just going to see. Give them some time to type. While we are waiting for more questions to come through, I just want to remind everybody that this session was being recorded. I will have it posted in the Commons by the end of today. I'm in Arizona, so it's about 2 o'clock here. I will have it up by this evening for everybody to access, along with Dr. Rebman's PowerPoint presentation. So if you have any further questions, I put Dr. Rebman's email address in the chat. Again, it's srebman, REBMAN, @ncu.edu, and you can send your questions over to her and she can address them there for you.
Most definitely.
Let's see. I don't see anything else coming through on my end that we haven't already gone over. So with that, what I will do is I will go ahead and close out today's session. And like I said, I will have this posted shortly for everybody. And I hope everybody enjoys the rest of your day. Thank you so much again, Dr. Rebman.
If I can just make one more comment, I would really like to thank the Center for Teaching and Learning for giving us this, this possibility to reach so many students at one time to discuss these fundamental issues that they will come to, at different programs or different parts of different courses, etc. But it was really nice to just be able to explain it one time and have it reach a number of different people. So thank you so much for the opportunity. I really appreciate it.
Well, we are very happy to have you. And we're happy to be of assistance for not only you, but all of our students in the program. So I hope everybody is able to click back into this recording when you need it. And if you ever need anything, please reach out to the CTL. Let us know if there are topics that you would like to see in the future, and we'll be sure to try to line up facilitators for the webinars. I hope everybody enjoys the rest of your day. Bye-bye.
Thank you.